Respected President and office bearers of the society, Mr. Vinod Jainji, and it's a distinguished class, accountants, company secretaries, and cost and works accountant. I was noticing one interesting, repeatedly, my predecessor speaker talked about professionals, advising clients. Of course, all of you are, but surprisingly, all of you assess the government. You basically run the finance and the economy and assist the government in the budget exercise all over. But unfortunately, the Ministry of Finance has roped all of you in by issuing notification dated 3rd of May 2023. I was surprised to see that notification. Of course, I'll deal with that little later. But for advocates also, perhaps there was some move. Maybe it has been dropped or not. I have no idea about it finally. But of course, Section 126 of the Evidence Act does protect the advocates. And basically, if I go to that, the basic idea is the communication between a professional and a client. That communication itself is a privileged communication. And you can't be forced or compelled to disclose that communication. That being a privileged communication, of course, there is a specific provision as far as the advocates are concerned, as I have told you already. But why should the other class of professionals be excluded from that criteria? They perform the same thing. Their act is equally important and advisory. But unfortunately, the ministry has issued, and it's going to have far-reaching consequences, I can tell you, as far as PMLA is concerned. It might even invoke 120B in some cases. I was dealing with the case of valuers, property valuers. They are also professionals. Originally, when the rules were framed under Wealth Act, the position was different, and over the years, the situation changed. And the corporate affairs, they started making rules and regulations, and the banks started involving them, and the CBI started prosecuting them. That matter is still going on. But why should a professional be involved in any kind of criminal act while exercising his authority as an advisor, as a professional giving advice to the client? That's exactly what every professional does. But unfortunately, the courts are also not. Of course, Supreme Court has said that all professionals, you are all professionals, that there is some protection. But the issue has yet to be ultimately gone into and decided, and that's what even the 3rd May 2023 notification issued by the Ministry of Finance must be taken up. I'm a little surprised why all these institutions have not collectively taken up this issue. The bar councils did at some stage, and maybe perhaps the ministry is looking for an opportunity to rope in the advocates as well. But if it happens, then perhaps there may be a different kind of agitation or protest and everything, for which the lawyers are well known. Coming back to PMLA, आप सब लोगों ने केज पैरट एक बहुत पॉपुलर सुप्रीम कोर्ट ने जब कहा सीबीआई acting in such a fashion. But unfortunately, PMLA ED has gone far ahead. They're exceeding their jurisdiction all out and out, and would, after Vinodji Jain Sahab had told me, and after having dealt with some of the provisions and cases of the PMLA, I accepted it. And when I analyzed and tried to present something for your benefit, possibly we would try to understand what is all is going on and what is PMLA all about. And that's what my effort is with reference to various provisions of the PMLA. Of course, there is a vast subject where unlimited sessions can be held. But I'm first trying to focus on the issue, what is the origin, how have the PMLA has come in? What was the need and where from the whole thing started? And kindly permit me to read this. The international conventions which have been well recognized, on the basis of which PMLA came in. And it was in implementation of the international commitment that the Parliament did it. Money Laundering Act 2002 was enacted by the Parliament as a special legislation to fulfill international commitments. Since it was felt that the money laundering poses a serious threat not only to the financial system of the country, but also to their integrity and sovereignty. In order to implement this international commitment, a bill was introduced in 1988, which was referred to the Standing Committee, and the report was submitted to the Lok Sabha on 4th of March 1999. Before going into various aspects of PMLA, as categorized in today's program schedule, we need essentially to understand that to obviate the threat of money laundering, the international community outlined the broad areas, namely the United Nations Convention against, and kindly note this, against illicit trafficking in NDPS, narcotics, drugs and psychotropic substances, and prevention of laundering of proceeds of drug crimes and other connected activities, and confiscation of the proceeds right from such offences. If we confine to this area, that's one area which originally the act was supposed to be, because NDPS activities across the countries is so wide and so much of money involved in it. Therefore, the international community first thought of to combat this kind of activities, and for this purpose the whole thing started. In 1989, according to the Basel's Statement of Principles, the basic policy on procedure to be followed by the banks, now the role has come to assist law enforcing agencies in tackling the problem of money laundering was declared, because if the money is transferred through banks across border to the different countries or even within also, then one can identify the transaction, the trail, and all those things which you people can understand better. During the summit of 7 major industrial nations, the Financial Action Task Force, and I think they are coming here in November, was established, which provided foundation material for comprehensive legislation to prevent money laundering. This happened at the Paris Summit from 14th to 16th July 1989. Another important development that took place at the international level was the political declaration and global program of action which adopted by the United Nations Convention to develop a mechanism that prevents the laundering of drug-related money. Here again they said drug-related money, and the enactment of legislation to prevent such laundering. The UN special session dealing with the world drug problem in June 1998 made another declaration regarding the need to combat money laundering, and India is a signatory to this. I have taken the time to mention this background because my argument, which and you would also appreciate, where now I'll refer to the latest judgment, which is popularly known by 3 judges of the Supreme Court in Vijay Madhanlal's case. Practically changing the judgment of the Supreme Court, earlier judgment, where they said striking down the twin principles for grant of bail under Section 45 of the PMLA. Even the Union of India in Vijay Madhanlal's case has emphasized these developments to buttress their stand that PMLA is a special law that stands alone and is not regulated by or in accordance with the general law applicable. That is why it's a special law. It's a different and totally different compartment. It deals with a different area. The crime is different. It is not, and it cannot be equated with the general law, the domestic laws, IPC, even the PC, Prevention Act, and so many legislations which were already in existence in India. But what ultimately the government did, that's something interesting. Let me just come to the definition. See, under Section 2, Clause 1P of the PMLA, it doesn't give any specific definition. Otherwise, normally in every statute we find in Section 2 itself the definition is there. But what it says is, means as assigned under Section 3. 3 is the offence of money laundering. More importantly, by adding an explanation to Section 3, inserted with effect from 1/8/2019, that's the amendment which was questioned, the scope has been further widened and enlarged. This amendment was through the finance bill. And one of the grounds for challenge was whether the amendment could be carried out through finance bill or not. But the apex court in Vijay Madhanlal's case did not go into this issue. Reason being, there was one more issue, Roger Matthew, which was referred to a larger bench. So perhaps they thought, let us see the outcome of that larger bench on this particular issue. So they just did not go into, but according to me, they should have, because it has a bearing as far as the amendments which have been carried out in 2018 and 2019 by use of this power under the financial bill, by enacting them this way. In P. Chidambaram's case, where the issue was the grant of anticipatory bail, the apex court defined money laundering as a process of concealing illicit source of money and the launderer transforming money received driving from criminal activity into funds moved to other institutions or transforming into legitimate assets. काले को सफेद. Basically, जैसे dry clean होता है, concept is basically the same. It doesn't change. But the question that would arise is, which money, which activity, which offense and which crime, which would be covered within the definition of PMLA and which will not be covered under this. The other laws, of course, they're already there. Take, for example, the Income Tax Act. That issue arises there also. And GST, I think, in some cases, PMLA has taken proceedings against some of the persons as well under both these acts because they are also covered under it. Justice Nariman, in the case of Nikesh Tarachand Shah, this was the where he struck down the twin conditions under section 45 of the PMLA for grant of bail, and that were notice to the public prosecutor who can oppose it. Second, to see whether prima facie or the court finds that there is no evidence, no material, and the person is not guilty about it. Offense. Those two conditions, court says no, it's violative of Article 14 and 21. Therefore, it was struck down. But the definition given by Justice Nariman was, and as he explained, what is money laundering and what constitutes offense under Section 3 of the PMLA is that kind of persons involved in money laundering is extremely wide. The words used as quote unquote whatsoever in Section 3, directly or indirectly, and attempts to indulge. These are the words mentioned in Section 3. So Justice Nariman said that this would show that all persons who are even remotely involved in this offense are sought to be robbed in. An important ingredient of the offense is that this person must be knowingly or actually involved in any such activity connected with the proceeds of crime. It may be important to understand. Now, I am coming to the second issue here, that under 2002 Act, schedule of offences is given. Some of the offences, I am not pointing it out, all the acts which have been included or which have been added even by amendment in 2019 or even 2013. But I am just pointing it out because I am raising an argument on that basis, and some of the acts are Indian Penal Code. NDPS Act, of course, yes. Explosive Substance Act, UAPA, Arms Act, Wildlife Protection Act, Immoral Trafficking Act, Protection Act, Prevention of Corruption Act, SEBI Act, and there are another list of at least 5-6 more which have been added here. This schedule of offences, according to ED as well as the courts also, is crucial, because if an FIR is registered under any of the offences in the schedule of offence, then PMLA, the ED will jump in. That's the kind of argument which is being advanced. But I have a difference of opinion on that, which I'll submit little later. But before that, let me point out that PMLA came into force on 1st July 2005. And there are three important areas, three important terms, terminologies which we need to understand, which are often deliberated in the courts, which include, the first is proceeds of crime. This is under section 2(1) clause U. Then comes schedule of offences, and this schedule contains part A, part B and part C. There are three different categories where the offences have been added. Initially it was something different. There were some additions made in 2013, I think 2018 and 2019 as well. So the government kept on adding. So increasing the area of jurisdiction to invoke PMLA. These have been defined under the Act. But there is one popularly known terminology when you talk to any senior person or those who have experience on that. I spoke to one jurist. I said, sir, what is this? Sir, why? It's a predicate offence. I looked into the PMLA Act. It's not mentioned. There is no definition under the PML, under section 2 or any other provision under the PMLA. But we did some research, and why I'm mentioning is, the reason is, again to come and demonstrate before this August gathering that this is a special law because it is in implementation of United UN resolutions and the decisions for a particular kind of and class of offences. Don't generalize it. Don't rope in anybody and everybody within India or within the subject area for a different agencies to investigate. That's not your compartment. Confined to it, but that's not being done. I'll just refer to this aspect that Apex Court in its latest judgment, Vijay Madan Lal, which is, everybody refers to this judgment, latest judgment, and perhaps this, after this judgment, ED feels they are the master of all. They have full power and authorities, and nobody to check, nobody to regulate. The court do not interfere under 226 or 482. Okay. So I'll try to cut short, but I just want to make a few important aspects of the matter. So the definition of predicate offence is, again we have to go to the International Convention, and there is a clause where the definition is given in Palermo Conventions, where the definition is. Why? Our Act doesn't say so. Now I'll skip and I will not go to the definition because I'll try to cut short. You see, it has a serious penal consequences. Just give me, because these are important aspects, maybe. The punishment is minimum 3 years and 7 years maximum. At that point of time, initially there was a fine of 10 lakhs maximum, but that was subsequently, as far as the fine is, deleted. But if the offence is relating to NDPS, then 7 years can go up to 10 years. That's what it says. Why I've said so? Because the NDPS is one activity where the maximum finance and illegality takes place across border. You see, I'm asking a question and I'm cutting short on this. The schedule of offences includes 302, murder. I asked some of the friends, I said, if a murder takes place and the police registered an FIR, will the PMLA come into action? ED will say, I will investigate it. Why have you included this offence? Not one, at least 20 offences under the IPC have been included in the schedule of offences. It's a joke, practically. But there is a point here. If supposing murder takes place, transnational in conduct of this activity, which is prohibited by the international convention from one country to another country in transfer of money from that country or this country to another country, then perhaps you can say that the real activity is that the murder has taken place because, but not in the case of general law which is applicable in India and governed by that. Then I'll just move further. There's some interesting observation made in Vijay Madanlal's case, which I'll just read with your permission. While considering the challenge to the relevant provisions of 2002 Act, we cannot be oblivious to the object and reasons for enacting such a special legislation and seriousness of the issues to be dealt with thereunder, including having transnational implications. Kindly note the words and the language. Every provision in 2002 Act will have to be given its due significance while keeping in mind legislative intent for providing a special mechanism to deal with the scourge of money laundering recognized world over and with the need to deal with it sternly. Therefore, this is totally a different area which has to be dealt with, but ED today doesn't look into it because they can just go and catch anybody and everybody. They have so wide powers. I am not dealing with Nikesh Tarachand's here twin area, but one thing I'll point out. Justice Nariman said this is violative of 14th and 21. Twin conditions for grant of bail under Section 45. Government brought in by amendment in 2018, 2019. So reintroduced it, and that was under challenge in this Vijay Madanlal. But since the challenge has been turned down, therefore the first earlier judgment for grant of bail also goes. Now no bail, and that's why the ED, most of the persons, those who are arrested, they are behind bars. That's the position aspects. And before I conclude, I'll definitely deal with this professional aspect and how the amendment has been surreptitiously included. It's very dangerous. Section 5 of the Act, Section 8 of the Act, there is an authority created who adjudicating, for adjudication. There is a power given for provisional attachment. There are reasons, circumstances which have to be gone into. I'm sorry to say, number one, these are judicial functions which have been assigned to them. The judicial member was supposed to be there, but perhaps the rules have been amended. The administrator, what kind of orders they pass? And nobody looks into it. And I argued for 45 minutes before the adjudicating authority that look at the kind of language and what has it done. But I knew the fate that he will dismiss. He will confirm the provisional attachment, which he did. Why I have said it? But that there is an open abuse of power in exercising this. There's two more important aspects. When this act gives you power for search, house search, personal search, inquiry, questioning, collection of documents and evidence, the power is given And CPC is applicable for that purpose. Civil Procedure Code. What are you doing? You don't comply with. You collect any evidence you want. If somebody has invested money in the shell companies, you can get the evidence. What is so difficult about it? Why hang the people? Why arrest them? Why put them to such a situation and make a media issue that yes, we are controlling and checking the corruption? Unfortunately, what is happening is, the moment an FIR is registered under PC Act, the entire everything is sent to the ED, and they register their case. It's not FIR. Supreme Court says no, you can't get a copy of it. Section 41A doesn't apply. CRPC, they can just go and arrest you. What kind of law? And unfortunately, if such a law is not struck down by the Supreme Court, which is out and out violative of Article 20 and 21 of the Constitution of India, the way I'll quote one with your permission. There was a question asked. Normally what the investigating officers do, sir, when the question of bail comes, sir, he is not cooperating. Second time when you come, no, he is not cooperating. He is not giving answer. Third time, no, we have tried, but he is not cooperating. The one judge asked the question, what do you mean by this word not cooperating? Do you mean to say that he should say and confess and say, yes, I have committed the crime? Then only you will say that he is cooperating. So that was the unfortunate situation which I wanted to highlight. And there are provisions under this Act which deals with this everything. The arrest is totally unnecessary. One can understand if some money trail or somebody involving terrorist activities, money come from across the borders somewhere else, then you can say and do it. But those are not the cases which are happening in India. Now I'll, with your permissions, come to this notification, because I am. This is the notification issued on 3rd of May 2023, and this involves CS and cost and works accountant. He said this has been issued in exercise of powers under Section 2, subsection 1, clause S, small s a, subclause 6. According to me, this is ultra virus. It's a subordinate legislation. The government doesn't have power to issue this. Why? Because I'll, with your permission, read this. There are 3 separate sections which have been added. 11A, capital A, then 12 was already there, 12A, capital, and 12 double A. Those have been added here, and section 12 already deals with one of the subjects which you have mentioned here is reporting entity. Now they are not saying directly that you become a reporting entity as such, but yes, they have done it. And how have they done it? And if you go to section 2, subsection 1, SA, and the clause is 6. I will, with your permission, just read it, because these are 2 lines. Persons carrying on such other activities as the central government may, by notification, so designate from time to time. Will the 3 category of chartered accountants and company secretaries and all, will they come within the meaning of this definition, this clause? This is the clause which has been invoked by the government for issuing this notification. And the basic question again would be, why should the professionals who are performing not as an employee, who are not, their job is very limited, performing the expertise, advice, giving advice on the basis of their expertise on the subject. Therefore, why should they be involved and in any case be brought in within the jurisdiction of PMLA by this article? We were discussing this issue when the question arose about the advocates, that something was there. I said, if you don't give the information, then also you are a defaulter. They may invoke 120B against you. And if you give information, then also it's dangerous. So, why are they having any intention to invoke 120B and institute criminal, and someday it might come? It's so horrible and kind of an act which has been a notification which I'm afraid all of you join together, and Minister of Finance should take up this issue, that withdraw this notification, because these kind of notifications are very dangerous. Thank you very much, and thanks to Binodji for giving me this opportunity. I hope there are more areas where we can some other time discuss and work it out. Thank you very much.